right? What a comforting transition. I want to thank folks for joining us this wonderful Thursday morning. For those of you that don't know me, I am Martin Daly. I'm the Director of Water Quality for the Capital District Regional Planning Commission. For those of you that do not know what the Commission does, we are a regional planning and resource center that serves Albany, Rensselaer, Saratoga, and Schenectady counties. We foster intergovernmental cooperation, communicating, collaborating, and facilitating on regional initiatives. We work with partners across the region to help them address regional problems, issues that are shared beyond the borders of municipalities. We historically organized 2 annual day-long workshops to provide training to planning and zoning board members, code enforcement officers, municipal officials, planners, policy wonks, those folks. But in light of New York pause and restrictions imposed by to stop the spread of COVID-19, we've canceled our spring workshop and moved our events online, which has provided us with the opportunity to kind of go outside of our traditional borders and get more people to dial into these webinars. These provide an opportunity for attendees to take this training back to their municipality for consideration of credit. Planning and zoning board members are required to obtain 4 hours of training a year, and this is one of the vehicles that they may use if their community accepts this as qualified training. In the same vein, we have submitted these webinars to the American Planning Association. This one in particular was submitted for 1.5 hours of law credits for AICP. So for those of you who are practicing planners, there are credits available to you through this. A couple housekeeping notes. Our attendees join with video and audio off for security purposes. That doesn't mean you're unable to ask questions, however, so please use the chat function or the ask questions button at the bottom of your screen. I will moderate and interject from time to time so we can pass your questions along to our moderator, to our presenter. We do archive the presentations as PDFs on our website, cdrpc.org. We, at the end of the session, each of the attendees will be emailed a confirmation email, and that will also provide a link to the area of our website where we archive our presentations. We also record these webinars, and a link to that recording on our CDRPC YouTube channel is also provided. So I'd recommend that folks like and subscribe to our channel, because we're oftentimes putting up content like the presentation you'll hear today, and it's an opportunity to not only view this webinar, but past webinars as well, and get notified when there are postings of additional material. With that, I want to turn it over to our Executive Director very briefly to see if I missed anything. You're on mute, Mark.
Having done these webinars multiple times, you'd think I'd know to take myself off mute, but thank you, Martin, always broadcasting from the basement, doing such a great job hosting these webinars. Since we kicked these off at the end of April, we have thankfully had more than nearly 400 people participate in these webinars. So it's an extension of the services that CDRPC provides to our counties and to the local governments within the counties, continuing the conversation about topical issues, in this case, planning case law, providing the information for our planning and zoning board members to hopefully make better and informed decisions at the local level. With that, I'll turn it back over to Martin to introduce our speaker, who we're so happy to have. She's a rock star when it comes to case law. Sometimes it can be a snooze fest, but Libby does not make it a snooze fest. So we're just really excited to hear what you have to say, Libby.
Absolutely. So for those of you that are just joining us again, we have our attendees on mute and on video, video blocked for security purposes. Please use that chat function in order to get questions across, and I'll be moderating as we go through this. In this webinar, participants will get the latest information on New York courts as they have reviewed and issued decisions on a wide variety of land use approvals and denials. If you're looking for insight on how courts thought about local planning and zoning decisions, this session will provide you with a close look at the laws and standards that are applied to both approvals and denials issued by your board. This session will also highlight teachable cases from across the state, which aims to provide a framework of land use law that can become usable by planning or zoning board members. Joining us today is Ms. Elizabeth Coreno, Libby. She is an attorney with a practice based in Saratoga Springs, and her practice is concentrated in real estate development, including acquisition, site selection, land use approval, finance, and litigation for a wide variety of industries such as hospitals, healthcare, and industrial. She often provides strategic guidance to private clients and as special counsel to municipal clients in the areas of environmental and land use law on a wide range of issues, including legal implications of board actions, the limits in municipal authority, and the application information necessary to enable a board to make proper determination. So with that, I'll turn it over to Libby. Libby, you have full control here of the ship. So if you have a presentation and want to do screen share, you are.
Well, I'll do that. Thank you so much to you both for inviting me. And I think this is my third time being able to be with you guys. And so my first time on Zoom. So the only thing I would ask is just for a little bit of patience and kindness, because I so love my live audiences. And so this is the first time for me. I want to say at the outset that, and Martin, can you just remind me, how much time do I have?
We have 1.5 hours. So,
okay.
Yep.
So then I think what I'll start with is the question that came in from Kirby on, because I'll start with the question first, because I want to be sure I get to ethics and public officers law, because there's been a lot that's happened with COVID. But I'll answer this one first, which is it appropriate for planning board or village board or town board or anyone else, leaders to prohibit residents from calling, emailing, or speaking with board members outside the public hearing dates? No. And there's a reason for that. The ethics around making decisions belong to the board members, not to members of the public. So what I'd like to have people think about this is, if someone's going to violate the ethics laws, or the ethics rules, then the people over whom the ethics rules, or the people to whom the ethics rules apply, are those in public service. So the residents may or may not be aware of what the ethics rules are. So you could remind them, you could give them a copy of the policy, but the people who are really the gatekeepers of whether or not there's dialogue outside of public meetings are our government actors, or quasi-governmental actors. So I hope that that answers the question. Just wanted to get to that one quickly. And there's some interesting ethics decisions out there about, my colleague, Mark Schachner, I think, taught on this and wrote on this once in a very, very detailed way. If I can put my hands on it, I'll get it to you guys and it can be circulated. But it has to do with, Americans' rights to lobby their government and how much you can really restrict, what happens outside of public discourse. And, is somebody allowed to take a meeting with a town supervisor, and how do you really prevent that? And, there's all kinds of different permutations of these issues. So the place to just, from the high level, is your ethics rules and your rules of engagement are governed to the actors, or the ones in public service, as opposed to the public. If that makes any sense. Did I answer that one okay?
I think so. And one thing I wanted to add that I think is a best practice, at least on the board that I serve on, is we're constantly reminding residents, if they have comments or questions or concerns, please send those to planning staff so they're part of the record. Because an informal conversation on the side may be very valuable to an individual board member's perspective, but we want to make sure we're communicating residents' concerns appropriately and recording those as part of the public hearing as if, just in case there's a challenge or other board members are able to access that information. So I can't stress that enough. I think it's a really good policy for your board to have, is please submit your comments in writing, even if you're uncomfortable speaking at a hearing. That way it's part of the record.
We'll take them. Yeah. And the other part too, I want to say this, because I'm not sure, Kirby, if this is in your question or not, but I was up in the North Country last spring teaching on at another conference statewide about being approached in the grocery store. But really what it was around was the impact of social media on the deliberative process and how that has affected and changed things in my 15 or 16 years of practicing, what that's meant. And so the other part to this is it harassing? So I don't know if that's in this question of residents calling or emailing to be harassing, and that's an entirely different thing. So if that's part of this question, I can address that too. But I started with the ethics, but if it's harassing, there are other things. And in those circumstances, you want to contact your municipal council to help give you advice about what your options may be if you're approached, if someone's calling your home, or there is a harassment element to this question. Just want to put that out there too. Okay, So I'm gonna see if I can screen share now, everybody. So bear with me, and hopefully there aren't pictures of my kids and my dog, and instead you see the presentation. So just hang on. All right, let me see if I can find it. Here we go.
If you're using multiple monitors, just beware that it's gonna.
I'm doing my. Can you see it now?
Yes, we can. Fantastic.
All right, let me see if I can get. All right, I want to go back. So, all right, good. Sorry, guys, I was playing with a little. So here's my. You don't need this one now, but this is my my lead.
Your head is right on my screen. Your face is right where your face is in your presentation too.
Oh, so I'm like talking, right?
Yeah.
Okay, so today we're just going to run through what I call just the umbrella of the most common land use decisions that get made in New York: area variances, use variances, interpretation cases, special use permits, site plan subdivision seeker, and the open meetings law and the ethics and some of the public officers law and some of the things that we were just talking about a second ago. So every single year, New York State comes out with, from the appellate division level, I won't go down to the local trial court level, but approximately 100 to 150 appellate division cases, and appellate division meaning they've been appealed but through the local trial court up to one of the 4 appellate divisions in the state. And so I read every single one of them, trying to get a sense of where New York is headed in context with the rest of the country. What are the courts looking at? What are the things that have moved and changed over time? And one of the most important things I think to remember, people give me this in my feedback, and I want to just kind of address it now. People say, why do you love zoning boards so much? You always have so many zoning cases. What about the planning boards? I love you too. It's just that there aren't as many cases for planning board members, and there's reasons for that. The first is that a zoning board really is a quasi-judicial body. It's governed by the state law. It has a quasi-judicial function, and it tends to be where most citizens will come up against a land use process. It just tends to be that way. The other is that in some of our more rural areas in New York, and if you find yourself there, this may apply to you, is that many times a municipality will not have a planning board. And so when you have a zoning, one of the sort of just black letter laws in New York is the minute you pass a zoning code, you must have a zoning board of appeals, but you don't have to have a planning board. And so some areas in the state where there is, whether it's the APA or there's other bodies that are handling things at the county level or whatever, the planning boards just don't get formed. And so we just see more zoning board cases than we do planning boards. So it's not a lack of love, it's just the way that the state is set up. So I keep trying to bring as many planning board cases as I can. But just know that that zoning just happens to be where we see most of this stuff occur. So we'll start with, and if you have questions, please ask. You know, I never know without the live audience how many of you are, you know, seasoned 30-year veterans of this process or brand new. So I try to kind of hit the middle, but if I'm moving too slowly or whatever, just let me know. Or too quickly for that matter. So the first one we're going to come to is an area variance. This is what I call the balancing test, and I have it on a little bit of a teeter-totter here to help you visually remember. So this is for our zoning board members who are being asked the question of whether or not they can use the area of their particular piece of property in a way that is different than the restrictions for their zone. So that could be, we hear words like setback and height variance, or lot coverage, or permeability, or all of these different kinds of things, which really means that the municipality has a way in which it wants certain parcels of land to be developed in a conforming fashion. But there are times where, you know, you need to be 2 feet closer, or you want to put that pool in, or, you know, and so the board has to take a look at, the zoning board has to say, is there a reason, a compelling enough reason, a balanced reason, to deviate from these restrictions, to vary, which is why it's called variance. So the 5 things that a zoning board is looking at for the balancing test is change. So will this proposal create an undesirable change in the character of the neighborhood or be a detriment to its neighbors? Substantiality, which is how big is this? How big a change? How far from the code are we varying? Was this issue self-created, which means did the landowner know what the zoning restrictions were when they purchased? Environmental, of course, will it have an adverse impact on the physical environment of the neighborhood? And alternative, which is there a benefit to the applicant that can be achieved by making it smaller or bringing it more forward? Or is there another way to build which could still achieve the desired result, but just not be as impactful to the neighborhood? So that's the lay of the land. And what's important to remember about the area variance test is, I teach this all the time, 3 out of 5 ain't bad. So it is more likely than not, meaning you can meet 3 of them, even if 2 of them aren't met, and still be able to grant a legal area variance if you're so inclined as a board. So I think that's the place to just to remember is all 5 do not have to be met in the area variance scenario. So I'll just do a few area variance cases. By the way, just so everybody knows, area variance cases tend to be the most voluminous number of cases every single year. And again, it's because it's where most citizens will find themselves in the municipal process. So the first one I bring you to is Pangborn versus Thompson, second department case. That's down Suffolk and Nassau counties. That's the second department. I'll try to do that as we go, just so everybody can get a sense of how the state operates. Second department, one of the busiest in the state, come out with more land use decisions than any other department in the state every year. I think that has a lot to do with the population density of the second department. And so that has had a lot to do with it downstate. So Pangborn versus Thompson, I think, is a great case for talking about this idea of feasible alternative. And I will say that from a trend standpoint in the last 10 years, the 2 areas of area variance testing where the courts are making the most amount of movement is in this feasible alternative area, as well as the substantiality. That just seems to be where there's a lot of focus right now, and we'll talk about that as we go. So in this case, 2 landowners enter into a contract where one intends to sell some land to the other, and they're going to demolish an existing single-family home and construct 2 two-family dwellings. So, you know, we're going from a demolition of one single-family home and then families. The result is that both lots would be rendered non-conforming under the zoning code, meaning both lots then have to be subject to an area variance analysis. The selling lot requires a small side yard setback, while the buying lot requires a height and lot coverage variance. So looking at 2 different lots, the impact of this land sale or this lot line adjustment or whatever it was now requires both lots to have this examination. And for those of you who are if you are in the planning and zoning offices accepting these applications, or if you're a code enforcement officer, this one is key because it really highlights the issue that that one of the things that brings on a variance is the sort of baseline rule that you can't sell something, you can't sell land or a portion of land to another person or to another lot holder or an adjoining lot holder if it's going to render either lot non-conforming. So that's just, people think that that's a lot line adjustment or a simple subdivision. So if you have that lot line adjustment, admin approval, minor subdivision provisions in your code, one of the things to understand is you do still have to do it. If you know this, forgive me, but you still have to do a lot coverage or an area variance calculation for all of your area and bulk restrictions before the subdivision can go through. And that's where we see it most of the time, is our very, very talented code enforcement officers doing those calculations and finding those things, and then letting somebody know, not so fast, you got to go through the zoning board process before we can even get to your subdivision. So I get those calls a lot, by the way, as a developer's lawyer. You know, wait a minute, now I have to? Yes, now you have to. So that's this case. And here, this is interesting. The appellate division determines that the selling lot was entitled to the area variance for the side yard setback as of right because, let me back up just for a second. The zoning board denies everything across the board. They summarily deny both lots. And what's important about this is that what the appellate division says back to the zoning board is this. One, the record in the case was sufficient for the selling lot to have the entitlement to the area variance. And if you remember, that was the side yard. And you can't lump it in with the other lot So they have to be heard again on their own merits, 2 different lots, 2 different assessments. So that was sort of rule number 1 coming out of that one. And it's also important to note that the appellate divisions can, if they see enough evidence in the record, meaning the applicant's materials, the minutes of the hearing, or the resolution, or whatever it may be, there was enough in there to grant the variance. And they have the power to do that. So that's something else to realize. They don't use it very often. So I would imagine that in this case, the evidence must have been overwhelming, because they will normally choose to send it back down or not supplant their judgment for the zoning board. So that's one. And the second is that on the piece, the other lot, the buying lot, they did send it back down to the zoning board to apply the 5-part test. But here's the piece that's critical, because a zoning board can't simply conclude the project does not have to be built to be a feasible alternative. And if I could tell you the number of times that trips up zoning boards that I'm in front of or that I advise, it's astonishing, which is you will hear a board member say, well, just don't build it then. That's the feasible alternative. No, it's not. Not building it isn't an alternative. It's basically, think about it this way. It's basically having a quasi-judicial body say to you, don't even apply. And that's not how it works in New York. In New York, you have the right to petition your government for relief. And so that analysis of relief cannot be, well, just don't file to begin with. You don't have to build it. You don't need the relief. That's not it. So remember that a feasible alternative literally has to be any alternative except don't build. That can't be ever a feasible alternative. So it went back down to the zoning board to consider it against the 5-part test while not saying don't build it. So I don't know if there's questions about that, but I do hear that one a lot. The next is, I'm going to have to figure this out, how to move my, oh, there we go. Because it covers up my words on my screen, the pictures, the faces. Okay, this is Schwieg versus the City of New Rochelle, again, Second Department. So the owner had 2 adjoining parcels, one which was developed with a single family home and one which was vacant, about 10,000 square feet. So in 2004, City of New Rochelle puts a moratorium in place that results in new zoning restrictions for the vacant parcel. And it renders it non-conforming by about 5,000 square feet. So the new restriction is about 15,000, right? But the city decides to include this savings clause that says if you met the pre-2005 frontage requirement, even if you're vacant, as long as it's held in different ownership, then we're going to hold you exempt. So fast forward 10 years, the owner sells the improved lot and then seeks a building permit on the vacant piece. So now remember, they've severed common ownership, sold the property, the one with the house on it, to somebody else, and now seeks a building permit on the 10,000 square foot lot, saying, hey, I was saved under this moratorium provision. And the ZBA says no. So what the court ultimately decides is that the ZBA crafted an extensive resolution. So that's one of the things I want you to remember. They write well. They document everything that they're saying, all of their findings of fact. They take testimony. They do a very good job with their municipal council and their advisors, their consultants. And they essentially say that on each of the 5 factors, the thing that really struck them was that it was a 33% request on lot size. And there's that substantiality I talk about again, which is really sizable, a third of the requirement in the zone. And people ask me all the time, is there a standard by which, courts don't go below? I'd like to say yes, but it really is up to the zoning board to decide. I have never seen a substantial case. I think I talk about this in other ones below 3% that was ever held to be substantial. So just so you know. Notably, the court said the petitioners were on notice of the upzoning, which took place 10 years prior to when they listed their house for sale and eventually sold their home. And they could have included the adjacent lot in that sale. And so that's that self-created thing. So they failed on that as well. So the thing to remember from the Schwieg case, I hope that's how they say their name, but the thing to remember from the Schwieg case is document, document, document. The better your resolution, the more findings of fact you put in there, the better chance you have on appeal. Okay? All right. Next is DeBordonnais versus the Village of Tuxedo Park. Again, second department, so we'll spend some time downstate, I think, for most of this presentation. The owner wanted to rebuild a stone fence along his property line and adjacent to a roadway, which required a variance from the zoning board. And BZA is just Board of Zoning Appeals. Downstate, that tends to be the old nomenclature. That was what New York City used. Upstate, we use Zoning Board of Appeals. The initial application neglected to include a line of sight variance as part of the relief, but it was added later. And then the board engages in the requisite balancing test, and a neighbor challenges the relief. One, saying that the initial line of sight variance was not included in the original application, and so that was outside of the board's jurisdiction to consider it. And that the public notice was insufficient on this point, meaning that when it went out and said, the public notice went out and said, hey, this is what we're gonna be talking about at the meeting, line of sight wasn't in there, and so people wouldn't know to come. So that was really the argument in layman's terms. So the court says, no, we disagree with you, neighbor. This is important to remember, I think, for those who process these applications. The jurisdiction of the zoning board rules of procedure are not jurisdictional, unlike other bodies such as state courts, meaning the board has the ability to exercise all jurisdiction over the property. So if there's a later prayer for relief that needs to happen, or this happens a lot, by the way, up where I am, zoning board members on Saratoga Springs are really sharp, really sophisticated. They've been doing this a long time, and they can look down at a map. I'm thinking of one member in particular who can do the calculations and kind of figure it all out, and then raise an issue and say, hey, wait a minute, doesn't this need a variance too? And so what this case is really saying is that's the jurisdiction of the board, is to ask, go back to the code enforcement and say, hey, wait a minute, they can't do it on their own, but to go back to code enforcement and say, hey, are you sure this calculation is right? And doesn't this require a variance? And then add it to the prayer for relief so that it's comprehensive and you don't bring applicants back over and over again. So that's what DeBordnave is saying is permissible to do. And I don't think I have it on the slide, but the public notice provision, just to kind of talk about that for a second, was that the court said, no, I mean, if you tell people come to a meeting because we're going to be varying this property, that's kind of enough. And so the fact that the line of sight wasn't included, the court wasn't persuaded by. It just said, there was enough for people to know that the board would be talking about this, and if you wanted to be heard, to come. So neighbor lost on both counts. Okay, somebody with a lot better pronunciation skills than me could do this one, but I think it's Mengesopoulos, Board of Zoning Appeals versus the Board of Zoning Appeals of the City of Glen Cove. Here, the owner resides in a 1- and 2-family residential zone and wants to convert her 1 family into a 2-family. So we don't have a use variance scenario here, but she applies to the city zoning board for a series of area variances, all which are denied. She then files the Article 78, which is what it's called, to challenge the decision. And the Supreme Court, the trial court in New York, we call that the Supreme Court. I won't go into why that is, but it's very old and very antiquated, but that's what we do. But the trial court grants the petition, right? So she wins, this landowner wins at the trial level. And the appellate division agrees and says that there's a difference between, and this is again something I really want board members to remember, there's a difference between engaging in a 5-part balancing test, meaning I'm going through the motions, and the requirements to really meaningfully consider the relevant statutory factors. So that is the standard of review when it comes to an area variance test, is to meaningfully consider the relevant factors. So looking for not just a cursory, perfunctory review. The courts really want to see that the board's engaged in that. So in this case, the consideration failed to provide a thoughtful review of the undesirable impact on the neighborhood, the physical environment, the detriment to the health and safety of the community. And then here you can see my phrase, in other words, 2 out of 5 is bad, because 3 out of 5 is okay, 2 out of 5 isn't enough. So what happened here was the board got stuck on 2 of the issues that they thought didn't pass muster, wrote the resolution that way, and the court says, no, we need the other 3. So that's just more of how to consider them. Any questions? I don't know if we got questions coming in because I can't really see them if they're popping in right now, but.
Nope, none yet.
No, okay. So we'll move on to use variances. So in this circumstance, use variances is different because you do have to meet all 4 standards. I like to tell people that use variances are the most challenging land use approval to receive. I kind of have them when I teach other programs. I sort of have them on this decreasing line from the hardest to the easiest from a standard of review standpoint, and from a presumption standpoint. And in the case of a use variance, the presumption starts in favor of the municipality, and it stays there unless significant evidence comes forward on all 4 of these elements. Okay, so use variances are hard to get. They are difficult to prove. And what that means is when you see a true use variance case, I know this is going to sound like Potter Stewart from the US Supreme Court, you know it when you see it. There's something about, and I tell people this, they don't believe me, but people will say to me, especially land use board members, Libby, I never see you bringing a use variance. Does nobody call and hire you for that? And I say, I have to answer. People call me all the time. I just say no a lot. Because, and what you don't see is the fact that I just don't bring them. Because I won't bring something I don't think has merit, and I don't think that the applicant could win. And so that's why, even for me, I think I've handled 3 in my years of doing this. And that's because I do know how hard it is. And if I don't think somebody can meet out the test, I don't take them through the process. So the first is, can the applicant realize a reasonable return if used for the permitted purpose in the zone? So we'll get into reasonable return. That area right now, this this idea of, are there other uses in the zone, the current use in the zone, does this give the applicant a return on their investment that's reasonable, right? Not the most highest level of return, just a reasonable return. As the applicants all the time make that case, like the highest and best use of the land is this. Well, that's great. Go put it in a conforming zone because it isn't here. So you see people conflate that sometimes. The next is, does the hardship result from the unique characteristics of the property? Like, is this a special case? And again, that's like one of those things where you know when you see it. The other one is the variance will not alter the essential character of the neighborhood. That's not putting an automobile repair shop in the middle of a residential neighborhood. That kind of thing, is it's so completely different. Or a trucking station. I saw that a couple of years ago. And then the big one, the one that's so hard to get through, has the hardship been self-created? And we'll see that New York is moving around on self-created a little bit, especially in a couple of cases this year. So my first is, right here in Saratoga Springs, 54 Marion Avenue versus the City of Saratoga Springs 3rd Department. That's up here where I am. So the petitioner wants to buy a vacant lot to construct a dental office. And so this one's been through the courts a couple of times. So if I don't read off the screen, I apologize. I just know this one. I know the lawyers that were involved. I watched the oral arguments at the Appellate Division. So this one is where the buyer wants to construct a dental office. And for those of you who don't know this corner, I'll describe it for you a little bit. It's on the corner of Route 50, which is an arterial kind of 4-lane highway crossed by Route 9, which, runs from the base of New York up to the top, and has a mobile station, a diner, and then some residential offices. But what's really unique is the development pressure that's come down from the town of Wilton on Route 9 and the city of Saratoga Springs from Route 50. So over the course of the last 30 years, what was once a quiet sort of backdoor, quiet, sleepy neighborhood next to Skidmore College had become sort of now the centerpiece of a major interchange between Route 9 and Route 50. So that's important to the background of this case. And so in 2018, the Appellate Division remits the case back down to the Supreme Court to reconsider the facts of the case after finding, this one was important in 2018, that self-created hardship can be overcome by circumstances outside of the property owner's control. And here, that was development pressure, as well as the uniqueness being articulated in the record, meaning that this was the first time I've ever seen the 3rd Department, ever. I've seen it in trial court level cases, but never at the 3rd Department level, essentially saying, if you own a piece of property that's been impacted by circumstances, even if you've owned it for 30 years, if it's been impacted by circumstances that was beyond your control, it can serve the basis of a self-created hardship argument. Meaning, I didn't self-create this. I bought this when it was a bedroom neighborhood next to Skidmore College, and decisions made by New York State DOT and the city of Saratoga Springs resulted in it becoming this municipal interchange and having development pressure beyond my control. And here the court is saying you get to make that argument now, which is very, very interesting, and it's a bit of a departure from what we've seen in the past. I mean, I think it's consistent. I think it's probably accurate. It's just we haven't seen it as much. So the decision by the court on this one goes back down to the ZBA. The ZBA again denies, goes back up to the appellate division, and the court says, listen, you're not unique. The traffic congestion and the that you complain of affects a substantial portion of this neighborhood and therefore can't be unique. And as to self-created hardship, the court says, good, I let you make the argument. So now you get to make the argument, but you still lose, and here's why. Because the property was zoned residential when you purchased it in '82. The evidence of commercialization was already starting and was foreseeable back then. And evidence of multiple prior use variance applications, marketing efforts as commercial, and the contributing factor to the economic impact by demolishing the building all required it to be denied. And so what I really want people to know from the Marion Ave case is every single fact matters in a use variance case. So the 2018 decision was saying, yeah, if you think commercialization has affected your property value and your ability to get a reasonable return, and that's not self-created, we'll let you make the argument, but then you have to have the facts to back it up. And in this particular case, the fact that the owner voluntarily demolished the building in order to make it a commercially viable listing contributed to its economic scenario on its reasonable return, and they just weren't going to give them the benefit of the doubt on that. So very complicated case, but very telling, I think, as we go forward. The next is White Plains Rural Cemetery versus the City of White Plains, Second Department. I think this case is kind of interesting for zoning boards who are kind of struggling with what language to apply to what, when. So here, a local rural cemetery, a non-for-profit, wanted to add a crematory to its operations and says, hey, that's within my pre-existing non-conforming use. And in the alternative, they say, okay, well, if you don't find that it's in my pre-existing non-conforming use, then I want to apply for a use variance, and the ZBA denies it across the board. We'll talk about interpretations of pre-existing non-conforming use later, but it's also within the purview of what the ZBA decides. So in that decision, first, the cemetery says to the ZBA, I want you to use the cemetery corporation definition under the not-for-profit law. I want you to apply that because it takes into account the fact that crematory are part of the uses allowed to a cemetery association. And interestingly, the court says no, the board's under no obligation to use a definition outside of its own code. So even if the state has a code provision that's broader as applied to cemeteries, zoning board doesn't have to use that. They get to use what's in their own code. And I thought that was interesting. Second, with respect to the use variance, the appellate division then does find fault with the zoning board. And this is what I really, really, really want zoning board members to pay attention to as it relates to financial data submitted on reasonable rate of return. 1, incorrect reading of financial data submitted because the board confused investment income accrued in the permanent maintenance fund with operating capital over the previous 5 years. And what that really is financial speak for they read the financial statement wrong. That's it. They read it wrong. They said, you can get this reasonable return because you have this permanent maintenance fund of whatever the endowment was, $50,000, $600,000. But that's all designated funds. It can't be used in the operational account. And so there really was no ability for them to stay afloat if they couldn't add the crematory. And so that's, I think, really, really important coming out of the White Plains case, which is, is the zoning board reading the financial data correct? The second is, this one's even bigger. The reliance on unrebutted evidence that the facility itself would be shielded from view, odor, emit no visible smoke, and passed all necessary air quality testing. This is really, really important, both on the financial and the environmental side. If the applicant submits evidence that goes unrebutted, meaning I try to do the equals, right? They submit expert testimony that says that sort of makes their case, and then it goes unrebutted from another expert. It's very, very hard at that point, and that's what the court is saying here, for a zoning board to use to just discount what the experts are saying without having rebuttable or rebutting testimony. And so that's going to be really true on your financials as well. If you're having trouble reading financial statements, get some help. If you're having trouble figuring out whether the applicant's consultant is telling you the truth or not, let's get help. I don't know. Martin, do you see that? I mean, what do you, in your own experience?
Yeah. When you talk about the financial statements, it historically has proved a significant challenge for the Board of Zoning Appeals that I serve on to be able to understand the pro formas. Sometimes gut check, if their maintenance fund or their landscaping fund just seems completely ridiculous, then you're able to kind of point to that and say, well, these numbers are not fudged or don't look reasonable. But
right.
it's oftentimes a question on where the board can go to get that outside opinion onto whether a pro forma is accurate, or they're just kind of plugging in numbers to be able to make a case for potentially upzoning the property, for example.
Yeah, and so I agree with that. And I think there's lots of techniques. There's ways that boards do dig deeper. Some of that is to require the actual supporting documentation as opposed to just the summary from the applicant. The other is to bring in the person who prepared them. Sometimes it's to ask a third party to prepare a statement, that says, whether it's a consulting accountant or whatever it might be, or to review it. So I think, but here, the thing that's critical about White Plains is incorrect reading of financial data can be really problematic. The other is that the board's focus on decreased property values, this is another one, was speculative and unsupported by the record. I see this all the time. Members of the public walk in, property values are going to go down, and it's the dentist talking. I mean, I love my dentist. I'm just saying, not have the credibility to, or the background or the ability to make a property valuation assessment. It's a layman speaking from what I have here on the slide, what the court's called generalized community opposition. So if someone doesn't have the requisite expertise to give an expert opinion, the board can't take it. Does that make sense?
Yeah, that's something we've always struggled with. Again, is because quite frequently the three things that are typically in opposition to a particular project are its impact on property value, which is very difficult to demonstrate. The second thing is traffic, which is also very difficult to demonstrate. And then the third thing is parking, which is oftentimes very difficult to demonstrate. If you're the average John Q. public responding to maybe a site plan presented by a company that's hired a traffic engineer that has put together a pro forma or has provided comprehensive financial evidence.
Right.
And it's really hard for the board to be able to take some of those more general public comments that are kind of just thrown out there, hoping that those darts will.
Yeah, and I think that's part of why these presentations are so important. The ability to hear, if the board was to hire me on a particular project to go in and kind of give the lay of the land of, attorney-client, here's what it looks like. This is how you make decisions. That can be very comforting because otherwise I think there is this assumption in the public that everything is up for consideration. That's just simply not true. Even legally, it's not true. And that can be hard to be the person, especially the chair, to kind of make those things clear. So I think, well.
In communities where they have a good process of being able to look at a pro forma or financial evidence that's submitted by an applicant, who does the requisite expertise on the board?
Yeah, you're saying that you have the expertise on the board?
No, if they don't, I mean, if we don't have somebody on our board, let's say, a scenario where a board is looking at a case and they see a very complex pro forma for a mixed use building or something where there's multiple activities going on, where can they go in their community to take that and kind of get a good opinion on whether those numbers are accurate?
Yeah, I think that's a good question. I mean, I have to go back to the statutory law because I can't remember. I know it's true for planning boards with how under site plan and special use, no, site plan specific, no, special use too, how to create an escrow account and how to have the applicant have to pay for the consulting review.
Mm-hmm.
And in some cases, I have to go back and see if that applies for zoning boards, and forgive me for just not knowing off the top of my head.
Oh no, that's a good something to follow up on.
But I'll go look at that. But part of it is to be able to go out and solicit the help that you need to be able to make those decisions. I can tell you from my own perspective as the attorney, I actually appreciate that. I appreciate opportunities that because I never bring a client forward with faulty numbers because it wouldn't be any good for my career. And, I like my reputation and my name. So, but I actually appreciate sometimes when there is that third party who can say, we've been through the numbers, what they're saying is accurate. I appreciate my engineers, friends and colleagues who do that from behalf of boards, my stormwater people, all of the people in the industry who are hired to advise boards, how much I appreciate them because, and I always appreciate all my own consultants, but because it up levels the conversation and it allows the public and especially the board to get the very best of at least the technical data to be able to make an informed decision. I just think those are the best land use decisions. I just do. I mean, anything else just feels shadowy and I don't know, just not above board. So, all right, I'm going to, because I know my time is running through here. So I'll try to do use variances quickly.
Oh, yeah, sorry.
Sorry. Oh, I'm sorry. Are there questions? I'm seeing something light up on my screen. Hang on just one second.
We had somebody comment that they believe the ZBA can use escrow accounts for third party.
Thanks for that. Awesome. Okay. I'll look that up. I mean, that's my sense, but again, I need to be careful what I, anyway, Delvecchio versus Collins, third department. So here, owner operates a stone and landscaping supply business, got a site plan and a use variance in 2001. The neighbor builds on the adjacent lot in 2003. And then claims that the expansion of the business in 2005 creates excessive noise and dust, happens all the time. Neighbor brings an action for private nuisance, not really something we need to worry about too much. And then to compel, this one's big, to compel the enforcement of the zoning code as it relates to unlawful expansion of the use variance. And so the court does not allow the neighbor to seek private enforcement of the use variance. That's really important to know if you're working inside municipal government. Is that there is no ability for a private citizen to compel code enforcement. Code enforcement is discretionary outside of really a lot of really tailored exemptions, and I won't go into those now. After the court reviewed the original ZBA resolution granting the use variance in the site plan issued by the planning board, it determined that the variance was unrestricted about the size of the business, but it was restricted by the site plan. And so therefore, a question of fact existed about how large the business could be under the approved plot plan from the planning board. So you'll see this one again, because it goes back down. Code enforcement has to make an interpretive decision about whether or not a site plan granted in 2001 allowed for expansion, not the use. So very confusing set of facts, but next year, I'll be back to report what happened. And that brings me to one point I really did want to mention. I go over this a little bit in interpretations, but it's so important for people to remember that the planning board and the zoning board are not interpretive bodies at first impression, okay? The planning board never is. But at a first impression, it's your code enforcement officer. Every single time, no exceptions, nobody else anywhere, not the town supervisor, nobody gets to interpret the zoning code except the code enforcement officer, and that is statutory law in New York, period. If either an affected landowner or the property owner themselves feels aggrieved, then they can take that interpretation to the Zoning Board of Appeals. But you can never take it to the planning board. So I see planning boards trying to interpret code all the time. Please don't. Please, please, please don't. You don't have that ability. All right, Route 17, real estate versus the Zoning Board of the Town of Newburgh, second department again. This one is really here just to talk about sort of the redevelopment. So we have an auto park that's being redeveloped, and a portion of the land was to be sold to a hotel provider, but there was all these variances that were needed. And this one had to do with a town that had a code provision that said hotels have to have a certain amount of principal frontage on a state or county highway. And so one of those was a principal frontage variance. And the neighbor objected, insisting that the principal use frontage requirement was a use variance instead of an area variance. And here, because principal use was in the title, that's what they hung their hat on. And the court disagrees because the area variance is always the proper standard when we're talking about dimensional or physical relief. So the way to distinguish that is to really remember, one has to do with how something's going to be built, constructed, or laid out on the site. And the other one has to do with what's going to be happening on site after it's built. And so that's the difference between a use variance and an area variance in its most simple terms. Okay, so hopefully I can move on, but there we go. Interpretations, I won't go into too much the background. My screen looks like it's a little hard to see, so I apologize for that. But this is 267B, that's in the town law. There's similar provisions in the village law and the city law. They match this exactly. So basically it says the zoning board can reverse, affirm, or modify any interpretation or determination appealed from. So the jurisdiction of the zoning board in interpreting only comes up on appeal. And they can do whatever they want with it. They can affirm it, they can make their own decision, they can reject it. They have carte blanche to interpret the zoning code. So we'll look at these interpretation cases one at a time. So the first is Fox versus the Town of Geneva Zoning Board of Appeals, 4th Department out by Buffalo. The owner builds a break wall and a septic system along waterfront property, and code enforcement officer interprets this as a fence under the provision of the zoning code, and he issues violations. And the owner appeals the decision to the zoning board for an interpretation of the code provision, which defines fence as any structure regardless of composition, and it goes through the whole definition. And the ZBA agrees with the code enforcement officer's decisions and finds that the walls were in fact fences under the code. The 4th Department reverses the ZBA, and on a very interesting distinction between pure legal interpretation and one that is not pure legal or fact-based interpretation. So here, pure legal interpretation of the code terms does not require deference to the ZBA as the finder of fact. And what that is a fancy way of saying is, if the ZBA is being asked, what do the words mean? Then it's a strict legal interpretation under their quasi-judicial authority, and they don't get to apply the facts. They just, what do the words mean? And there's no deference, meaning the court will not defer to the zoning board in its fact-finding authority. The second interpretation, the second kind of interpretation, is one where the zoning board is applying the facts to the code. And in that circumstance, there is deference applied. So this is the first. So what the court tells the zoning board is all words within a code provision matter. I beg everybody to hear this. All words within a code provision matter and cannot be interpreted so as to render any of them meaningless. Here, the undisputed evidence was that the break wall and septic walls were erected to protect from soil erosion related to the lake, not to enclose off or divide off a parcel of land, which was the language in the code that a fence is something that encloses a piece of land or divides a piece of land into distinct proportions. And because that section was ignored in the interpretation, there was a reversal. So that's a pure legal interpretation. The next is Northwood School versus the Joint Zoning Board of the Town of North Elba. That's up in the 3rd Department. That's actually, I think, out by Lake Placid. Donor left a single family home to a boarding school to be used for student housing with a live-in faculty supervisor. See these a lot. The school was denied a certificate of occupancy and appeals to the zoning board under the interpretation of single family because it was in that zone. And the code defines family as a group of people, related or not, living together in a common household with a number of persons that impacts typical to that single family. So the zoning board holds a hearing where evidence is introduced that the students, the student identities would change every year. They would leave on breaks. They would not maintain a permanent residence at the location, or permanent address, I should say, at the location. And meals would be eaten in a separate dining area. And the court says and again, here you see very deliberative difference from Fox in Northwood, which is the the ZBA was applying the facts to the code provisions. And in that case, you can see the court defers, says, ZBA, you're the finder of fact. You know your municipality. You took the evidence. We'll just defer to what you thought. And so in those types of fact-applied scenarios, the ZBA gets deference, and they were successful. Next is HB Donuts versus the Town of LaGrange, Zoning Board of Appeals. Here, second department, owner maintains a non-conforming gas station. This case is great. So a fuel delivery truck hits a light pole, not great, but just a crazy set of facts. Hits a light pole, spills 3,000 gallons of gasoline onto the property, which closes the property for 2 years. The town has one of those sunset provisions, you know, that says if you stop using your non-conforming use for more than a year, you abandon it, right? Except in circumstances of casualty, meaning an accident or an incident, which this clearly was. So the owner of the Dunkin' Donuts challenges a building inspector's interpretation to permit, the Dunkin' Donuts across the street, challenges the building inspector's permit to allow the operation to reopen, as well as 1 year to complete the upgrades to the store itself. And it's important to know those upgrades were not damaged in the spill. The ZBA affirms the decision and of the building inspector to allow the reestablishment of the non-conforming use, but denies the application to upgrade the store, and the neighbor appeals. Here, the court finds the ZBA had a rational basis, which is the standard of review, to conclude that the cessation, the stoppage of the non-conforming use was directly tied to the spill, but that the store restoration was not. And as a result, it was sustained. So here you see a zoning board doing really good work in being able to track the facts to the code, to the interpretation, and apply them in a reasonable and rational way. So essentially, the store closed, and because they were not operational, but it was not impacted by the spill, and so they were under an obligation to complete those upgrades during the 1 year, not the 2 year. So very interesting. Tough result for the owner. Tough result, but probably the right one.
Libby, that's because it was a non-conforming use that couldn't be expanded in their code?
Yeah. Yep. And so, yeah, they operated it. Yeah, there was no ability. I mean, they'd have to go back and get a use variance now. I'm sure it's not over with, but yeah, that would be a use variance scenario.
So in this case, they were looking at upgrades, not expanding. How in your experience, how does code differentiate between what would be cosmetic improvements to a business, say new tables or chairs, or if the business changed their logo? In this case, they don't really have a choice on some of the upgrades. And what is defined as an expansion of a non-conforming use? Well,
I think what courts will look at when you're looking at an expansion scenario is what was contemplated at the time of inception. What was happening? There's sort of like 3 points of interest. What was happening at inception? What was happening at the code change? Because they may not always be the same. And what's happening now? And so when you look at pre-existing non-conforming use, what you're really looking at is how has that changed over time, and is it still consistent with what was happening time the code changed? And the best example of that came out, I think, in 2017 when it was dealing with a wood chipping plant. And it was a very, very interesting case about the scientific method and about how wood chipping had changed over time, and they had to keep up with the regulatory requirements and those types of things. And so when you have a ZBA really doing their job, what they're looking at is this really contemplated by the original use and the original inception, just updating through scientific method, or is this changing to a new market or trying to go beyond what was in the original inception, beyond just market and regulatory changes? Does that make sense? So yes. That's what we're looking for. Here, I haven't talked to the lawyers in this case. I'd have to imagine, though, from my memory of reading this one was, I don't know if it was like adding counter service or there was something additional that was going to bring in additional
maybe a drive-through. Yeah, something.
Yeah, that wasn't there before. And okay. I think that was it. That was the stopping point.
Thanks.
Sure. So this yeshiva case really does astound me a little bit. So in this one, yeshiva operates a non-for-profit school for boys in Brooklyn, and then they have this large parcel of land, 23 acres, within the town of, what is it? It's Wasaring. I can't remember say it right. Warising. Anyway, sorry everybody out there if I just butchered that.
Warsing.
Warsing.
Yeah.
Okay.
It doesn't roll off the tongue for us
So
upstaters.
bad. People keep inviting me back, but I always butcher it. The school applied for a site plan review for the renovation of the structures on site for an overnight camp, males ages 12 to 17, and the application gets denied, saying that essentially it's not compliant because it's outside the scope of the definition of places of worship. And the decision is then affirmed by the ZBA, which says the camp, it's more that the use was more akin to a camp than a synagogue. That was really the finding. And in reversing, the court says they use the plain language standard, meaning what does it really just say? And the court notes that the definition of place of worship included inside the code related on-site facilities such as monasteries, convents, rectories, retreat halls, school halls, or fellowship and school halls. And it's clear that the intent was for religious overnight stays and that the definition was in no way unambiguous, that monasteries and convents specifically, by the way, when you read the decision in its full, are overnight locations. So, you know, it didn't make any sense. So here, you know, I think the takeaway is not allowing decisions to be so attenuated from the plain language that they just border on, you know, they don't make sense. And I always know there's reasons, by the way. I never found there to be like a wholly irrational zoning board. Well, I can't say never, but most of the time I don't. And there's usually a reason. But what happens is it's in public, there's 7 people, 5 people, depending, you know, all going back and forth. And we get trapped on little issues or things that really we can't resolve because we're so used to trying to build consensus. And sometimes we lose the forest for the trees. And I wonder if this is a little bit what happened here. I have a question from Paul. What level of proof is required about what the original non-conforming use is? We have a question in our town about whether this was a non-conforming use was grandfathered in over 30 seconds. But now the neighbor claims that the use has expanded beyond that, very similar to that case, right? But doesn't have concrete evidence of what the original use was. Can we consider this? This depends. And the question, Paul, for you that I don't know is how has this complaint arisen? Because everything in ZBA world is jurisdictional. So the first place is either a complaint has to be filed or an interpretation has to be made by the code enforcement officer. So my first question back to you would be, how is this coming through the process? Because that's really, really indicative. It's the first stop. First base is somebody's got an issue, to whom do they bring it? And in this circumstance, you're talking about a neighbor who's got an issue about how an adjacent parcel is being used. And so I believe if, you know, I don't know your town or your village or your city, but my thought would be the first stop is how is it being complained about and to whom?
Libby, on that question, who gets to decide whether that party might be aggrieved or whether they have standing in order to bring something before the zoning board? Would that be the board?
Well, that's a really tough question. I actually just went up. Well, it's interesting because this case just went up to it's actually at the 3rd department right now, where, you know, our standing issues, statute of limitations, the non-substantive issues, are they jurisdictional to a zoning board or not? Case of, you know, I can't tell you the amount of work that my team did trying to get an argument around that made for a case that we have up here in Saratoga County. But so what you're asking me is the difference between substance and procedure and what's what. And so my argument, and I'll let you know next year if I won or not, my argument is that it is the zoning board's determination on procedural issues, not an enforcement officer. An enforcement officer is able to interpret code. What does the code say? Mm-hmm. As far as standing, as far as statute of limitations, that's for a board to do with their counsel. And then administrative official who should be standing between, because otherwise, and this was my argument, you're in zoning purgatory. You can't ever get to the body of relief because an administrator is telling you you can't even get a hearing. Mm. I think that's how, in my opinion, I'm a little passionate about this because I argue this one, but I don't think that precluding applicants on procedural grounds to get a hearing is the intent. So first answer is I think standing is handled by the zoning board.
And then we had one more question. Is it common practice or a good idea for a municipality to have a code enforcement officer on the planning board or zoning board?
The same one?
Yeah, I don't think that would be appropriate.
That would be an impermissible conflict of interest.
Yeah.
Yeah, no. No, and I think there is so much in the law and in the statutes about keeping those roles separate,
Independent.
because for all kinds of conflict reasons. Yeah. I do know that there are code enforcement officers who work in one municipality and sit on a zoning or planning board in their home municipality. If that's the case, that's a very different question. So if that's the question, that's okay. What that code enforcement officer has to do, though, is, and I see this with lawyers too, has to remember that they're just one vote and they're not the consultant for the board, and they're wandering into that expert testimony area.
Okay.
It's a whole thing. Special use permits. So this is one of those areas where it's generally in New York handled by planning boards, but there are many, believe it or not, many zoning boards who will handle special use permit, as well as the legislative body. There are some municipalities in New York that will still issue their special use permits through the elected officials, whether that be the town board, the village board, city council. So a special use permit means there's been a finding of uses in a zone. Those are your permitted uses. You come in, you just get a building permit, you're good to go. And then there's those that say, we like these, but we want somebody to look at them a little bit more just to make sure that there are reasonable conditions that'll be attached to that permit so it doesn't become unduly obtrusive. The most famous one is special use permits for drive-throughs. That tends to be a big one. Like, we like the bank, but we want to look at the drive-through. We want to look at traffic. We want to look at the curb cut. We want to look at flows of nearby properties. So that's a common one that I like to use. So, but we want to look at the drive-through, that kind of thing. The thing that's important to remember about special use permit, though, is what's in italics midway down the slide, which is that a special use permit is tantamount to a finding that the permitted use is in harmony with the zoning plan and will not adversely affect the neighborhood. Sometimes I see planning board members treating a special use permit like a use variance, as if it's sort of a use that the town or the city or the village did not intend. They did. If it's if it's listed as a special use, it is consistent with the comp plan. It is consistent with the large scale zoning plan for the municipality. It's just being looked at to determine whether or not it can be adequately implemented without being disruptive. So you're looking more at the impact of the use than you're looking at the validity of the use itself. And I hope that makes sense. And we'll go through some of the cases so we can see. I brought Saratoga Springs zoning code just to show you some of the things that Saratoga looks at, and you can see it has to do with implementation, harmony, compatibility, vehicular congestion and traffic, infrastructure, utilities, impact on the environment, and the long-term economic stability and community character. So you can see here that same kind of thing. It's not really the use itself, it's the implementation of the use. So here we have a few. Michaelis versus the Town of Half Moon Planning Board. This is 3rd Department. Half Moon is in Saratoga County. There's been a golf course out there since the 1990s, operating pursuant to a special use permit. It has a clubhouse, a pro shop, a restaurant, and a banquet house. In 2017, the owner wants to go on and expand the business operations to allow for an on-site beer brewing. I don't know. You can't call a beer distillery, so I can't remember what it's called, but I apologize.
Brewery.
Out there, shout it out. It's
brewery.
Brewery. Yeah, so it's
a microbrewery if they're brewing on premise to serve. Yeah.
You can see I'm very up on my alcohol creation. Yeah, no. So anyway, they want to brew the beer on site, but not for outside sale, just to be able to offer it to their customers. And so, but they're an ag res zone and it's not allowed. And so the code enforcement officer gets the application and he says the brew pub is an extension of a special use permit granted in 1990 rather than being a standalone review under the zoning code. And so the planning board undertakes the review and they apply their special use permit criteria and they grant it's subject to a series of fairly extensive conditions. Actually, if I went back and read the resolution, I mean, it's fairly extensive. So they're narrowly tailored to ensure that the brew pub truly functions as an amenity and not a standalone operation. And so in that circumstance, you can see that even the extension of the special use permit starts as an interpretation issue and then ends up being resolved, but all happens correctly. Resolved by the code enforcement officer, hears the complaint, renders the decision, goes on to the planning board. The planning board accepts that decision. They don't argue with the code enforcement officer about whether or not that's true. And then they go ahead and apply their special use permit criteria to allow it to go forward. And they apply some very, very tailored conditions to ensure that it doesn't impact the neighborhood in a negative way. So Miklas is a great case for how it's supposed to work for sort of from start to finish, even if you disagree with the outcome. Matter of Quick Check Corp versus the town of Islip. This is a 2018 case. I brought it because it's just one of my absolute favorites when it comes to, so it's a year behind, but when it comes to special use permits. So here, the owner has a 2-acre parcel with a used car dealership and a car repair shop and a storage for boats and vehicles. And then in order to redevelop the site, they need a special use permit to add convenience market, minor restaurant, and gasoline service station. They conduct public hearings and the planning board grants the special use permit for the convenience store, but they deny the application to permit the gasoline service station, and the owner challenges. So here, this one is, I just think, so important for those of you who are looking at the planning level for traffic. The court held there was no showing that the use of a gasoline service station would have a greater impact on traffic than any other of the unconditionally permitted uses. Thus, the court held that the alleged increase in traffic volume was an improper ground for the denial of the special use permit, and any of the other reasons set forth by the town board in support of the denial were conclusory and unsupported by factual data and empirical evidence. So as such, the court held that the material findings of the town board were not supported by substantial evidence and upheld the Supreme Court's decision to grant the special use permit. And I just want to highlight to everyone how important I think that is. If you are sitting on a planning board and you are looking at a special use permit and you are moved by the traffic evidence, please remember the matter of Quick Check Corp, because it will say to you that the analysis for traffic isn't necessarily just, will it create traffic? It's asking you now, will it create traffic beyond the permitted uses in the zone? Because it cannot be that a town board intended no traffic to be created, otherwise they would have zoned it differently. So it's very important to remember that you're looking at the delta between permitted and specially permitted, not down to zero. And so I hope that that makes sense. It's a very nuanced issue. I remember reading it for the first time and thinking, wow, that's new, and that's gonna affect some things. So if you find yourself saying, no, there's just too much traffic in this area, okay. But if we were to put a permitted bank there, if we were to put a permitted coffee shop, if we were there to put a permitted laundromat, would you feel the same way? Would it be the same traffic impacts? Because if it would be, you can't deny on those grounds. So I hope I explained that okay. Site plan. So again, site plan has to do with more, I'm so sorry. I don't know what I just did there. Okay. So site plan has to do with the way a site is laid out. And there tends to be very, very few site plan cases in New York. And the reason for that is this. Outside of truly an unsafe condition, most site plans can be engineered in a way that is safe, unless it violates, regulatory restrictions or stormwater management or wetlands issues, but that's all different, So here we're looking at parking. So we're really talking with the planning board about how to orient the site, not whether the site's going to be used. So it's parking, means of access, screening, signs, landscaping, architectural features, location and dimensions of building, and adjacent land uses. So that's what we're looking at. The only, I don't say only, but one of the only cases I've ever seen where a site plan got denied was in the case of a dirt track in someone's backyard where they had the jumps, sort of a dirt bike track, and the trajectory of the jumps would have had the opportunity to take a dirt bike rider off a jump and into somebody else's yard or somebody else's property. If they were to be injured or going fast enough, they would just launch off property. In that circumstance, the site plan was denied because it's unsafe. So that's kind of thing we're looking at there. The rest of it really is a discussion of, you know, how to orient things. And for this particular reason, and for the next slide, you'll see is that we didn't have a lot of site plan cases this year. So I just wanted to go over what site plan is, and then of course the requirements for subdivision, which planning boards look at too, and then we'll look at the cases next. Is that subdivision is then the breaking up of land. So as we move down the sliding scale of land use approvals, we started out with use variances toughest. We get down to subdivision, which really should be the most, you know, the easiest to get. So long as you can show that the plat can be used safely, that there's adequate roads and grades, that there's suitable marks and blocks, compliance with all other regs, and that often can be supplemented by local restrictions too. Also, if required by the board, the parkland designation, people get confused on that one, but that's part of the subdivision discussion. So site plan cases, town of Mamakating versus the village of Bloomingburg. Here, third department, 2019, the town and village were subject to an intermunicipal agreement. If you've never seen one of those, that really has to do oftentimes with land that goes across more than one municipal line. So, so they're going to have to review the project for a townhouse complex, but it's wholly located in the village. So the town seeks to annul, so the village is inside of the town, so they're making this decision together pursuant to certain rules in the agreement. In summary, the town sought to annul the decisions made by the village 6 years beforehand, and a 2016 reaffirmation of those decisions leads to the current dispute. So there are 10 years in dispute here. And essentially what happens is the town claims that its reaffirmation of the 2010 site plan approval was arbitrary and capricious, and the court disagrees. So here, again, we're going to look at some site plan issues with what are we looking at and how are the courts looking at evidence. So the court notes that the applicant has submitted extensive analyses from engineering experts regarding the roadway expansion involving stormwater and traffic. While the town made competing findings, it was within the village planning board's authority to rely on the recommendation of its own engineers, the review of the reports, and finding of no impacts. Moreover, the planning board was entitled to credit the evidence submitted by the applicant's engineers over that of the town's engineers. So what's happening here is the town in which the village sits is having they have a dispute about how to read the engineers, the applicant's engineers' technical data. And the village consultants come back and say, we agree and it's fine and you can rely on it. And the town comes back and says, well, no, we hired a whole other engineer who disagrees with it, and, you know, and on it goes. What we call in law, the battle of the experts ensues. But the reality is that, and this is hard, I think, for a lot of people to accept, is the battle of the expert ends. It has to. These disputes can't go on forever, and they usually end either with a vote, or, as it happens here, the strike of the pen of the third department, who says, I'm going to resolve your issues for you, which is that the village board has every right to rely on the evidence that came before it, even if the town has competing testimony. So this is really a lesson in planning board's ability. I shouldn't say ability. The planning board's discretion, better word, the discretion to choose which reports it's going to credit almost as the finder of fact, like the jury. And that's kind of the role for the planning board. I'll harken back just for a minute to say that's different than the public coming in and saying, I think there'll be traffic problems. That's not an equal resolution of expert testimony. But if a planning board is really eyeballing expert to expert to expert, in this case 3, they're entitled to pick, and the courts will defer. So just remember that, you know, as you go through and look at these kinds of things. One is the substance and the quality of the information that you're looking at, making sure it has parity or equality, and that ultimately somebody gets to make that decision. And it starts with the planning board. And unfortunately, sometimes it ends with the court, but those do get resolved. The next case is involving the subdivision and site plans to build 4 single-family homes on 43 acres in an ag overlay district, and had received conditional approval and then amended its plans in 2013. In all of this case is wild to read. In all of this, none of the planning board's approvals ever permitted construction in the northwestern corner of the lot. And there's reasons for that, and it has to do, I believe, with the soils. By 2015, the owner had switched everything around, away from 4 single-family homes down to 1 single-family massive home, and then sites it in the northwest corner of the lot. So the record says that the board properly considered all of the site plan factors. So this is, this will be great. I say, and then I ever hear site plans being denied. That the village code governs the site plan applications and had already made a determination that the northwest corner of the property would contribute to the loss of ag soils, and that such development would negatively impact the views and vistas of the farmland areas, and that it would have a negative impact on the future subdivision of the property. So a finding of a lack of suitable location for development was not illegal, arbitrary, or capricious, or an abuse of discretion. So here's a case where, from a site plan perspective, the board was not obligated to accept the applicant's desire to use the northwest corner of the property, and instead was entitled to say, here is and you can see I put it in italics, the actual evidence of the soil suitability and the negative impact on the future subdivision of the property based upon soils was a sufficient expert testimony to do what is rare, which is deny a site plan approval. Now, if you read the case, I'll just be honest with you, there's a lot more going on here about the board and their feeling of this particular case. I think, just so everybody knows, it's just, I believe that they had seen this application for a long time, never being able to pick a spot, never being able to pick a final development plan, those kinds of things. It just, and then to come back and say, okay, well, I know you already decided in 07, we weren't going to put anything there, but now I'm just going to put a house there and I'm going to leave the rest of it for development later. Like, I wasn't born yesterday, that kind of thing. That's the feeling I got. Livingston Development Group versus the Village of Dobbs Ferry. So this is the site plan approval to construct 2 6-unit condominium buildings overlooking the Hudson. The planning board does the extensive seeker review, which includes the watershed analysis. They recommend to the village board to grant site plan approval. And then the board of trustees issued the site plan, but conditioned it upon the review by their architectural and historic review board. That board denies the approval on the grounds the buildings were excessively dissimilar to the surrounding neighborhood, and the applicant appealed, stating that the planning board had jurisdiction over the views under its seeker review, and that site plan authority and the other review boards are prohibited from making inconsistent findings with those findings. And so the court notes that while that may be true, because it is, the ZBA's determination was not solely based on the viewshed impact and therefore could not be deemed arbitrary and capricious. So the reason I bring Livingston forward is just to let everybody know, generally it is true that you can't, a subsequent board to the seeker findings can't make findings inconsistent with seeker, even on their substantive approval. However, they can make anything else. And so if the zoning board's decision, and I didn't get to read it, but if the zoning board's decision was in fact based upon other things, so be it. Campaign for Buffalo History, Architecture, and Culture, Inc. versus the Zoning Board of Appeals of the City of Buffalo, 4th Department, obviously out by Buffalo. The owner brought an application for variance and site plan approvals to a project that would demolish, I think it's a series of existing residences and then and garages, and then replace them with 3 mixed-use buildings, an art gallery, 8 apartments, this kind of. And the owner also planned to renovate a former church building located on the adjoining parcel, and it received all the approvals to permit its performing arts center. So we have a concerned group of citizens, as you can see, Campaign for Buffalo sues to challenge the site plan approval, among other things. So the decision was, the court disagreed that the planning board's approval of the site plan was inconsistent with the city's comp plan, and held its determination had a rational basis and was supported by substantial evidence. And so again, here we're looking at this idea of the planning board kind of doing its deliberative work and really having to withstand challenges from citizens group or from the public. They just say, well, these are historic buildings and they shouldn't be taken down. They don't have the ability. There are things where the planning board just has the limits of its power, and you see them here in the campaign for Buffalo case. I'm going to skip over seeker. They're in the materials if you guys want to read them, but I know we're running out of time, and that there are other seeker opportunities to learn that from much better teachers.
Yeah, we'll share the presentation on our website for folks that want to read into those cases.
Yeah, let's talk about open meetings for just a minute, because it's happening right now with COVID, and there's some things I just want to touch on. And that's changed a little bit from when I first developed this presentation. So there's two cases in here that are important: Chestnut Ridge Associates and then Davis. But I want to read from Chestnut because I think it's critical right now. So the court writes, in enacting the open meetings law, the legislators sought to ensure that public business performed in an open public manner and that the citizens of this state be fully aware of and able to participate or able to observe the performance of public officials and attend and listen to the deliberations and decisions that go into the making of public policy. So the reason I want to start there is because part of what we're dealing with COVID is this issue of, can the public meaningfully participate in a public meeting? That's one thing, that's Zoom meetings. And then can they meaningfully participate in public hearings? And how do you ensure that that goes on during this period? And there is a lot, believe it or not, of debate and dispute around that right now. And I just, bring everyone back to this, which is that you may see longer public hearing times during COVID to allow the public to write in when they would otherwise be unable to participate in a public meeting. You may see, this continuation of Zoom, and you may see, distancing where, for some very sophisticated municipalities that I'm talking to, the meeting is broadcast, and then people have to come in outside the meeting room, and then people can come in one at a time to the microphone to give their comments. So we're going to be navigating this quite a bit as we go on. And so I just wanted to, I won't go into too much more discussions right now, because I really want to save it if there's questions out there about what you're dealing with from a public access standpoint under COVID. And with my last 3 minutes, I just wanted to ask that. Is anybody concerned? Oh, there's a question. I attended a presentation a couple of years ago where I cited how prior decisions of the ZBA could establish precedents. Oh yeah. Yeah. So absolutely, in the sense that, let me just get to that one really quickly so I don't leave you guys hanging. Yes, precedential effect is one of the biggest elements of operating on a zoning board. And it essentially means you can't find something, you can't arbitrarily make a decision on one property that is substantially similar to another and come to two competing results. So courts are always going to be looking at the precedent that the board has been operating under and look for consistency. That's both true in opposing parcels, or not opposing, but in different parcels around the municipality, but it's also true on the same property. So if a decision was made in 2007 and a completely different one is made in 2017, and the only change is the passage of time, you're going to have a precedent problem. So yeah, precedent is really, really important. And I'd be happy to give whatever cases you think you need on that one, because they're ripe, meaning there's lots of them. Okay, so I didn't know if I had any other questions, but if there's anything else that comes up or anybody wants to reach out to me, you have my contact info.
It doesn't seem we have any more questions at the moment. But I do want to share my screen just to show folks where on our website this material will be shared. We have an archive of our planning and zoning webinar series at cdrpc.org. And if you visit the website, you'll see not only links to prior presentations in the archive materials, but you'll see upcoming presentations as well. So this is our website for all those archival materials. We'll certainly archive this one as well with the slides that Libby shared in her presentation. And once our video is done processing, we'll put that on the website as well. I don't see any other additional questions, but so I do want to thank Libby for her time today. Really appreciate that. There's a lot of material to cover in an hour and a half. So thank you very much. If folks have any questions, feel free to reach out to me. My email address will be on the automatic email that's generated at the end of the presentation. I would certainly be happy to pass some of those questions you may have to Libby herself if you do have those questions. With that, I will close out our webinar. Thank you so much.
Thanks, guys. Have a great day. Bye.
Bye-bye.